My name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate the public, so please subscribe to our channel. Today we're going to talk about mediation. And in the context of that, whether that is preferred to a court setting for custody. Well, on the one hand, a mediation environment, which is a non-court environment, it's an informal environment. We do it here in the office. Parties are separated in one conference room, then another party in another conference room, and there's shuttle diplomacy going on to try and arrive at an agreement. There's what to be said for that. It keeps the open lines of communication open. It inspires some level of cooperation. The nature of it is that it is child-focused. It should be child-centered. What's in the best interest of the child? And in that sense, perhaps a mediation may be more effective. I'll tell you one thing, it's certainly more cost-effective than going to an expensive child custody trial. The problem is, in some cases, you may just not be able to work it out. In complex cases or cases where parties are, digging their heels, they're drawing the line in the sand and beyond which nobody passes, in that situation, mediation might not work because you might not have the parties in the right headspace in order to be able to come to an agreement. Remember one thing. Ultimately, in most divorce cases, in most custody cases, I'm talking maybe 97%, those cases are settled without a trial, without the benefit of the court making the final ruling. But it rarely happens until people are ready to sit across the table and actually work things out with each other. If you cannot get the parties to sit at the table, mediation is not going to help, and the court's going to have to make the call. In some cases, there has been such a breakdown where the parties simply, even for the benefit of the child, cannot put their differences aside. The law is great for statutes and for precedent and all that. You can argue the law and you can deal with the precedent, but let's not forget one thing. There's a human element associated with this, and very strongly in family law, particularly in custody. Beyond the law, there's human beings involved, and that means there's going to be feelings involved. There's going to be hurt, there's going to be possible resentment, and those have to be navigated in order to work out the deal. Sometimes you just can't get beyond that. In that case, you go to court. And you put it in the hands of the guy who wears the black robe, and you know what? He or she, they're going to make that call, but they're not going to do it until there's witnesses called, there's cross-examination, there's briefs filed, there's pleadings filed, there's appropriate court procedures adhered to, and all of that is put together, and ultimately the court makes the rule. And if you don't like the ruling of the court, then, well, you go to the Court of Appeals, I suppose, and try and get a more favorable ruling there. Very difficult to do so. Everything that I described as we talked about the court, it requires considerable allocation of time and considerable allocation of assets. So yes, it's better to do it in a mediation process from the standpoint of getting it done quicker, getting it done cheaper, and the finality of it is the parties arrive at an agreement. But it's not always practical, and it won't work for everybody. If you have questions about whether it'll work for you, let us know, and we'll be glad to try and help you out.